So what happens when two of the most powerful branches of a democracy go head-to-head? We're diving into a really tense constitutional standoff that's happening in India, pitting its Supreme Court directly against the government. And what's at stake here? Well, it's control over these crucial legal bodies and maybe the very principle of judicial independence itself.
Okay, so let's set the scene. Picture a courtroom in India's Supreme Court. It is packed with tension. On one side, you've got the country's top judges, and on the other, you have lawyers for the central government. The air is absolutely electric, and what's about to happen is going to reveal this deep conflict that's been simmering for years. I mean, just listen to the bluntness of those words. That was the Chief Justice of India speaking directly to the government's lawyers. See, he was about to retire on November 24th, and he was basically calling them out, questioning if they were trying to drag out the case until he was gone. It's a really rare, candid moment that shows you just how much mistrust there is between these two powerful institutions.
So what is this fight really about? Well, it all comes down to one single piece of legislation that has turned into a massive constitutional battleground, the Tribunals Reforms Act of 2021.
First off, what even are these tribunals? Well, you can think of them as specialized, fast-track courts. They handle all sorts of specific things: corporate law, tax disputes, patent issues, you name it. Their whole purpose is to give expert rulings quickly, and in doing so, they take a huge load off the regular court system. They're a really vital part of India's justice delivery machine.
Now, the government's 2021 Act was meant to streamline this whole system, merge some tribunals, set new conditions for their members. But here's the part that caused all the trouble. It gave the central government the power to make the rules for appointments, tenure, and salaries. This centralization of power, well, that's the very heart of the conflict.
And believe me, this fight did not just appear out of thin air. This new act is really just the latest chapter in a long saga of legislative and judicial push and pull over who truly controls these powerful bodies. Just look at how this whole thing escalated. It really kicked off in 2017 when a new law gave the government power to set the rules. Then, in 2019, the Supreme Court struck those rules down. So in 2020, the court itself suggested some key changes, specifically a 5-year term for members to make sure they're independent. But then, the government used a temporary executive order, an ordinance, to push through its own rules anyway, ignoring the court and setting a shorter 4-year term. The court, again, struck that down, calling it arbitrary. And then, in what looks like a final defiant move just 1 month later, Parliament passed the Tribunals Reforms Act, putting that exact same 4-year term right back into law.
So, this legislative tit for tat brings us right to the core of the disagreement. It's a real clash of fundamental constitutional principles, and both sides are arguing that they're the ones upholding the proper balance of power.
Okay, so why is a single year of tenure so important? Well, for the judiciary, a short 4-year term makes tribunal members feel insecure. I mean, imagine your job security depends on the same government you might have to rule against. It just screams conflict of interest, and they argue it completely undermines their independence. They also say a minimum age of 50 cuts out a lot of talented lawyers. But the government fires right back. They say setting these conditions is a pure policy matter, something for Parliament alone to decide. They argue the age limit ensures experience and maturity, and that it's actually the judiciary that's overstepping its authority and messing with the whole separation of powers by getting involved in lawmaking.
So we've got this high-level constitutional battle raging. But why does any of this matter to you, to an average citizen or a business? What are the real-world consequences of this standoff?
Well, here's the bottom line. While these two branches of government are locked in this argument, the entire tribunal system is basically grinding to a halt. All this political and legal uncertainty has created a massive logjam, and it's preventing new members from being appointed to fill all the empty spots.
And the scale of this problem is just staggering. Take the National Company Law Tribunal. It's absolutely vital for businesses. As of late 2022, it's supposed to have 32 members, but 24 of those spots were empty. It was operating with only 8 members. That's just a quarter of its necessary strength. It means justice is delayed simply because there's nobody there to hear the cases.
The situation got so bad, so dire, that the Supreme Court itself used the incredibly strong phrase, virtually defunct, to describe these tribunals. For all the people and companies who rely on these bodies for swift, expert justice, the doors are effectively closed.
And this all brings us back to the huge, fundamental question at the heart of this conflict. It's a question that really defines the balance of power in any democracy. Who gets the final say? As this tussle between India's government and its judiciary continues, the answer to that question is still very much up in the air.